present and online. My name is Vellah. I'm a professor here at the law school and the director of the Queen's International Economic Law Centre. And it's my immense pleasure to be able to introduce our speaker for our second seminar this semester, who is Vellah Kigwiru. I hope I pronounced that adequately. If not, apology. So she's currently a research fellow at the School for Governance at the Technical University of Munich, previously a legal analyst at the Competition Authority of Kenya. And her PhD is focused on the regional regulation of competition law in COMISA, and looking at it from a comparative perspective with the EU competition law framework. And her presentation today is based on her ongoing research on competition policy in the context of the African Continental Trade Agreement. And it's called the Reimagining Trade Agreement and Competition Law under the AfCFTA in the era of international economic law dynamics. So without further ado, I can hand over to you. Before I do that, actually, just in terms of the format of the presentation, Vellah will present her work for 30-40 minutes, and then hopefully at the end we'll have an opportunity to do some Q&As. For those who are online, please feel free to use the comment box and we can read out your questions. And now I'm going to finally let you take over. Thank you very much.
Okay, thank you so much for that introduction, and also thank you so much for the invitation and for giving me this opportunity to talk about how Africa is reimagining trade through competition law enforcement. So I'll just discuss the basics about African participation in international economic law. Then we discuss the African Continental Free Trade Area, and then how trading under the AfCFTA is ongoing so far. And finally, we discuss the enforcement of competition law. So as we all know, the development of international economic law has been dominated by Europe and North America, and African participation is limited because of many factors, including the effects of colonialism, and also just the state of development in this kind of region. And also, in addition to inferiorization of the knowledge produced from the global south, is also intellectual marginalization, whereby the knowledge that is produced from the global south countries is inferior, or is an exception at the normal rule. So, because of these legacies of imperialism, there's a call to reform international economic law and increase the participation of countries that were not there when this international economic law was being established in those years. So why should Africa have a deep understanding of the international economic law? So there's an increased demand for African resources. It has always been there. There's increased regional integration with African countries, seeking to increase trade among themselves, and also supporting African firms not only to participate in inter-African trade, but also to participate in global trade and compete with the international firms. And also we've seen the effects of the recent global challenges, the COVID-19 pandemic, the Ukraine war, climate change, technological development, showing that we need a global coalition in addressing global challenges, and how these challenges are economically connected. So the growth of the global value chains, regional value chains. Remember when there was the Ukraine war and the issue of African farms having to access wheat from Ukraine affected and so on. So we need to resolve these challenges through coordination and cooperation. So because there's been a need to increase African voice, and institutions like Afronomics Law, African International Economic Law Network have come up to provide a space whereby we can discuss these issues relating to sovereign debt, management, issue of climate change, and other issues that African countries are seeking to enhance their voice. So African countries have used regional integration as a defensive tool to increase African to address the issues of African marginalization in global trade. And when we look at some of the distinctive characteristics of African participation in international economic law or international trade law, you see that in some cases they deviate from the normal rules that we know. So for instance, whereas in the EU, we'll see the issue of formalism and the strict adherence to rules and so on. In Africa, the way African countries view regional integration is underpinned on the principle of flexibility, which simply means that this is a platform for cooperation. So you'll find that when it comes to issues like domestication of treaties, so that the international law would have direct applicability in domestic markets. Some countries, even after ratifying their treaties as early as 1990s, they have not been able to domesticate this. But it doesn't mean that the regional integration is not working. It's working, but in a cooperative mode. And also the way African countries view regional integration, although it is underpinned on trade liberalization, they see regional integration as an avenue to meet other goals. It could be human rights, but it involves a multiplicity of goals. So it's not just one goal. So because the adoption of laws, especially international laws, is influenced by external actors, with the European Union playing a major role through technical assistance, especially in the development of competition law, we observe that most of the competition laws in Africa or intellectual property, they reflect the EU intellectual property, even data protection. Like most of African countries, they have modeled the data protection laws in regard with the GDPR. And now we're having the Digital Market Act that is not likely to be similar, but we'll see how it happens because most countries are now trying to have an inward looking when it comes to adoption of laws. So although supranationalism, which means that the establishment of an international institution that make legally binding decisions like the EU Commission and some of the some of the regional institutions in Africa also are supranational. But when we go to the practice, and I'll talk about it in relation to competition law, you find that the way they interact, the way the national competition authorities or regional competition authorities interact is more cooperative, even when the institution is supranational. So these are some of the defining distinctive aspects of African countries when it comes to international economic law. So here we have the African Continental Free Trade Area. There's only one country that has not ratified the African Continental Free Trade Agreement. And you can see we've created a very big continental market. This is the second largest economic bloc when in regard to participating countries next to the World Trade Organization. So with this creation of these markets, we're going to observe a case whereby even though the main objective was to increase inter-African trade, third parties and other countries would also like to benefit from this market because with more than 1.3 billion consumers, especially in the digital age, everybody wants to benefit from this AfCFTA. But if we want to understand the development of the AfCFTA, we have to understand it from African countries' efforts to unite, especially after colonization. So we trace it back to the Abuja Treaty, whereby African leaders convened to discuss how to have an African market that will enhance the development of African businesses or African firms, increase the participation of African businesses in the global trade as well. So we have to look at it from that point. So it was also in response to the protectionist measures that developed countries have undertaken. And we observed that the participation of African countries in global trade is very low. But also we observe that African countries rarely trade with each other. So even when we're having this AfCFTA, we are also having economic partnership agreements between African countries and third parties, especially the US and the EU, are taking place. So So when we look at it, we have to look at how this is going to happen in practice. So what is really happening with the AfCFTA? So far, we've had all the protocols that are going to support the enforcement of the AfCFTA. They have been drafted. In the second phase, we had the protocol on competition policy, the protocol of intellectual property, the protocol of on investment. So we are still just waiting for them to be ratified by the member states. And also the third phase focused on the protocol on digital trade, which is also has been drafted, and also the protocol on women and youth. And then we have all the protocols on trade in goods and services, which are going to support the enforcement of the African continental free trade area. So trading under the AfCFTA began in 2021, but just to start and test how it will happen. So the AfCFTA Secretariat launched the Guided Trade Initiative. So this GTI, the objective was to ensure that it will allow trading among firms within the AfCFTA, and also to test the operational, institutional, legal, and trade policy environment, and also to send a message to the private sector that trading has started. So the first trading occurred between Kenya and Ghana, whereby the first consignment involved Kenya exporting tea from Nairobi to Ghana, but now we are having more than 37 countries which have joined the GTI. But you can only join the GTI if you have the agreed rules of origin, and also you finalize and publish your tariff schedules according to the requirements of the AfCFTA, as well as the fact that you've enabled the customs system to receive goods under the agreement. So recently we've seen Nigeria and Kenya also are trading under the GTI. But the GTI, it's a mechanism to test the trading, but we observe that it's also showing the principle of flexibility that African countries still adhere to, and also the principle of variable geometry, whereby some countries are less developed, others are developed, so we have to give them time to adapt and so on. So far in a recent publication by the UNECA, that's the United Nations Economics of Africa, where they've tried to test what are some of the challenges those countries that are involved in GTI are faced. And some of them include most countries or most of the firms that participated in this trading, they don't understand the import and export procedures in specific countries. And also they thought that trading under the GTI will give them zero tariffs on goods and also waiver on tax. So there's a lot of there's need for awareness and more understanding of what the AfCFTA is all about. There was also high entry cost for SMEs who did not have funding to purchase some of the storage, distribution. So there was high storage and distribution cost, there was challenges with securing funds, there was high compliance cost, licensing, issues to do with licensing and so on. So all these challenges, the logistics, transportation, and so on, are some of the challenges already that these countries are facing. So we know that competition law generally is a regulatory policies that seeks to regulate competition among firms, ensure that there's an equal playing field for everybody that enters the market. The goals are different. Some would say the main goal of competition is consumer welfare. Others would say, no, let's focus on efficiency. And now we have issues to do with public interest consideration. But the adoption of competition law in Africa is a bit different from other countries because now it's happening at 3 levels. So we have the national competition regions, the regional economic communities are also having regional competition regions, and now the AfCFTA has a protocol on competition policy. So we are going to see how this is affecting trade and the development of international economic law. So this was the status in 2020 in a paper I wrote with Professor Tim Buten, whereby we had few countries in the second last column which had not adopted competition laws, but now we know Uganda has a competition law. We are waiting for the operationalization. Ghana is in the process of drafting a competition law, and so on. Congo now has a competition law, and some other countries have now operationalized their national competition agencies. But most of the substantive provisions focus on mergers, cartel conduct, and consumer welfare. They still face the similar challenges that any competition authority will face, such as inadequate resources, political interference, issues to do with sector prioritization, and so on. And then we see variation also in different countries. Some countries have independent competition authorities that is autonomous, others they have department within the ministry, and this affects how enforcement of competition law happens. For example, Ethiopia had an autonomous competition authority, but then they disbanded it, I think in 2022. Now they're also now trying to establish one. So in addition to that, there's also regional competition regimes in different regions. Africa, initially, it was all about, let's have an African economic community, but then the regional economic communities became the regional blocks towards establishing an African economic community. So we have different ones from, like, when you look at the West Africa, we have the economic community for West African states, and then now they have the Anglophone, so we have the West African Monetary Union and WAMS as well. And then when you look down south, we have the South African Development Community. And then we have the East African Community. It's only the Central African countries that have one regional economic community without countries having overlapping membership. And then we also have, these are the regional competition regimes, but we also have other regional economic communities for North African countries. So when you look at this table that Professor Tim and I worked on, you realize that so for firms that would like to participate in this African market, especially those that are involved in mergers and acquisition, you have to comply with different regional competition regimes. And now that we have the AfCFTA competition protocol, which will focus on the entire Africa. So for the AfCFTA competition protocol, it will focus on only conduct that has a continental dimension. Meaning that for a farm operating in Africa, you have to know whether your merger has a national dimension, it has a regional dimension, or also whether it has a continental dimension. And then for some of these countries that have a dualist legal system, the questions of applicability of these laws in the domestic market also arises. I will discuss that in the slides that comes. So this is how the regional competition regimes look like. So when you look at COMESA, the Common Market for Eastern and Southern Africa, which should be in color, I think in color purple. So you see like Malawi is a member of COMESA, is a member of the South African Development Community. You see Kenya is a member of the East African Community and also the member of COMESA. And this is why my PhD focused on how this interaction occurs in practice. So they also vary in substantive provisions. Some of them have state aid provisions, others have consumer welfare, others do not have consumer welfare, others have, I think most of them, like the West African Monetary Union doesn't have consumer welfare provision, ECOWAS doesn't have consumer protection provision, and also the AfCFTA competition protocol does not have the consumer welfare provisions. So these are some of the things that firms have to really look into. So when we look at the AfCFTA competition protocol, one of its unique features is that under Article 11 of the protocol, it's providing a legal framework for regulating digital markets. But when you look at that provision, most of the provisions is like they emulated the EU DMA at that time because we drafted it in 2022 in Accra, Ghana. So the protocol says that the Council of Ministers will adopt regulations to designate digital gatekeepers, And some of the prohibited conduct include self-preferencing, imposition of steering provisions for those who have some knowledge on digital markets. But still, it's going to face the same challenges that COMESA faced, especially the question relating to the applicability of the protocol in domestic legal system, especially in countries with dualist legal system. And then one of the issues, as I showed you, there was overlapping membership and the question of how do we allocate cases between a regional competition authority and a national competition authority. And this has really been a big challenge that is affecting trading among countries. So those are some of the issues that I'm going to look at. So it's been argued that one way of developing international economic law is for global South countries to look at their context, their realities, and develop laws that reflect the challenges that they face. So that we are having, it's not about only legal transplant of international laws, but we are also developing laws that are going to address some of the challenges. So when you look at the economic characteristics of African markets, we have informal markets, and then some of the challenges that they're seeking to address in unemployment, poverty. We have SMEs that would like to participate in the market and compete against the big firms. And then we have unequal economic and political power distribution. And this unequal economic and power and political power distribution can be traced back to colonialism. So in most countries, when the white people left, they left most of the economic power among the political elites. And these political elites are still controlling these farms. But like in the case of South Africa, the 1994 apartheid regime, even when it came to an end, already the regime had segregated the Black South African from the white South African, and the government at that time was supporting the white business firms. So you find that the business firms that are there, most of the ownership is represented by white people. And that is why when South Africa got independence, Black empowerment was one of the main priority for this government. So when you look at the goals of competition law enforcement in South Africa, you will see different goals compared to the traditional goals of competition law. So we have ensuring the spread of ownership among the historically disadvantaged persons, and also ensuring the entry and the participation of SMEs. And there's a debate on whether this should be a feature of competition law enforcement. Because in some cases, there's a merger that does not raise any competition concerns. But then it raises a public interest concern. And that merger is not approved just because of that public interest concern. So, so in order to have an inward-looking competition law enforcement or international economic law, we are observing a number of countries repealing and amending their competition laws to address specific market realities that just go beyond the traditional goals of competition laws. And it's taking a social approach, which is considering the economic and distributive implications of enforcement of competition laws. For example, poverty and poverty elevation and exclusion, and also public interest consideration, which, as I was discussing with Professor Rido, is non-exhaustive. It can be anything. It can be environmental considerations. It can be about the ability of SMEs to enter and participate in the market. The list is very exhaustive, but that is exactly what the African Competition agencies are looking for. And because the South African competition regime is the most established, so initially, for those who've studied policy diffusion, it was all about the EU, the US, through emulation, lesson learning. That's a mechanism that were influencing the adoption of laws in developing countries. But now we are seeing the diffusion occurring among these countries. So with the South African Commission regime being the best established, there's a lot of literature on the South African Commission regime. Most of the African countries that are now developing the commission regimes are looking at exactly what is happening in South Africa. So you see, most of the commission laws in Africa have public interest provisions. For example, when we look at the Botswana Competition Act, so we have the issue of promoting exports from Botswana, employment, advancing strategic or national interest, social benefits, citizen empowerment initiatives in government, competitiveness of SMEs, and also other programs that regards to the development of Botswana economy. So the enforcement of these commission laws has to work hand in hand with government projects as well, because most of these commission agencies are also funded by the government. So competition agencies are using public interest consideration either to approve mergers, to grant exemptions, and also to access cartel conduct. So same to Zambia. I've talked about the South Africa, the ability of SMEs to enter into the market, the control, the ability of farms that are owned by historically disadvantaged persons as well. And also the ability of these African farms to participate in the global trade. And you will see this occurring in digital markets. And I was discussing with Professor Ravi recently, there was a case of Lottoland in South Africa, which is a company that offers bets, on bets. And so now for a farm to really like make profits and sales, they have to be on Google search either. And Google search uses its Google ads to not only raise revenue, but to provide farms with the ability to reach more consumers and also to increase its visibility. So they excluded Lottoland from the Google ads, and Lottoland went to the South African Commission to complain about it because they wanted to be boarded back. And the South African Commission Tribunal has given an interim relief before the cases. It has provided interim relief, but it has argued that this is a refusal to deal, and because Lottoland really needs to be on the Google search engine, so they have to increase the participation of these firms on this kind of platforms. And the justification of what Google gave, which was it said that Lottoland was not complying with the Lotteries Act. It was found that it was not that justifiable at that time. So these are some of the things that you've seen how to increase the participation. So this is what I was talking about. So when you look at the Venus model, whereby it's like countries will trade with each other, or they will trade on each other because of trade liberalization of the benefits that come from trading. But when I was working on my PhD, and I went to the Commerce Competition Commission to find out exactly how is it happening in practice. When do national competition authorities, because when we talk about national competition authorities, we are linking them to member states somehow. When are they willing to support a supranational institution? So in this case, I found that the principle of flexibility still applies in practice, and the issue of inward-looking national interest, member state interest, really influence how national competition authorities interact with the Competition Commission. And because national competition authorities are key actors for enforcement of international laws, or let's just say domestic actors, because domestic actors understand the domestic markets. Domestic actors are the ones who will push for adoption of laws that support the application of international law. So even the United Nations, in some cases, they have to have good relationship with domestic actors, because these are the people that push for application of international economic law. So like the Commerce Competition regulation is an international economic law because it's above the member state level. So its application when it comes to domestic enforcement, when I interviewed the national competition authorities, I realized that when COMESA considers the interests that national competition authorities have raised, and this interest include employment, then it becomes very easy for these national competition authorities to work with COMESA and also to push for that enforcement at the national level. And working with COMESA includes, for the COMESA Commission to get information at the national level, it has to with the national competition authorities to get that information from the businesses. And in some cases, you'll find that some businesses will want to just apply for merger notification with national competition authorities, maybe because it will favor them more, and unfortunately the merger has a regional dimension, it has to be filed with the COMESA Commission. So in some cases, the national commission will be like, no, this merger is supposed to be filed at the COMESA Commission, you have to file it there with them, yeah. So these are some of the issues we're looking at when it comes to how we can imagine the application and the development of international economic law when it comes to competition and law enforcement, or how this competition law enforcement is informing the development of international economic law. So the COMESA Commission, these are some of the mergers that it has had to look at some of the national level interest. I remember making this presentation in Poland, and there's this merger whereby I think Professor Lennis was like, hey, Vellah, how can a sentimental value be a consideration in a merger transaction? So in this merger, the Coca-Cola Subco merger, it was buying the Castle Malawi Limited, but there was an issue whereby the Subco drink in Malawi, it was argued that the Malawians have a sentimental value. For those who, for Kenyans will say we love Tusker because, or if in German is that beer. So the Malawian consumers of the view that even when Coca-Cola is going to buy the Castle Malawi Limited, they should continue producing Subco, just because they have a sentimental value. And therefore, while the merger affected other countries, the COMESA Commission approved it with condition specific to Malawi, that for certain years, you should continue producing this thing. So those are the inward-looking considerations that competition regimes in Africa are considering when it comes to development of competition law. They contextualize the African market realities. So in addition to competition concerns, so that is how the law is developing in this country. So this was also in Zambia, whereby Access Bank was also purchasing the Atlas Mara Zambia, but this Atlas Mara had many subsidiaries in different parts of Zambia. And it was thought that they have to continue retaining people working there because people are going to lose their jobs and so on. So the COMESA Commission was, okay, when it comes to Zambia, then you have to honor all the employment contracts within a specific year. So public interest consideration is one of the things when it comes to enforcement of competition law that we can say is providing a voice to African international economic law. And national level enforcement agencies, regional, continental, are looking into these issues, into developing international economic law that will address these challenges. So when we are rethinking international economic law and how the AfCFTA and competition regime is informing the development of competition law, is like we are taking into consideration the historical trajectory of colonialism, inequality and exploitation, and how this has affected access to markets. So the principle of equality, whereby we know the SMEs, if they are not supported, if they are not given, I don't want to use the word favorable treatment, but there's a way in which that institutions are looking into ways of ensuring that there's inclusivity and we are creating room for participation. It's the same way with the Digital Market Acts, where the EU was of the view that although some will debate and say the Digital Market Act is a protectionist tool that only seeks to protect competitors rather than protect competition, but in the words of Professor Brandes, who argued that you have to protect the small businesses from the big firms because they have the power, and they don't only have the economic power, but they also have the political power to influence the adoption of regulations. They lobby, they have the money to lobby for this. So the small businesses will not be able to really participate in this market if we don't look for ways in which we can enhance their participation. So when you look at that, is one of the things that enforcement of competition law is doing. And how can we rethink this? What is the way forward? I'll always say in the words of Professor Olabisi and Professor James Garvey, who are the editors of Economics Law, is that we have really to encourage the scholarship on the Global South, whereby we give the Global South the chance to write about exactly what is happening in these geographic areas without forcing them to tilt their theoretical frameworks or the conceptualization towards Eurocentric context. And once we give them the freedom and the space to do this, then we are able to give the regions that did not participate in the development of international economic law the chance to start developing their own voice. And we also need to reflect on how colonial legacies will continue to influence the development of international economic law, the issue of economic partnership agreements, and how African countries trading with third parties, and at the same time, how we can also enhance trade among these African firms. So issues to do with trade preferences among different countries is very important. And also, this one, I think we've talked about it, the need to reform international economic law to reflect these issues. So that is it. If you want to follow some of my publications, this is what I've been working on in relation to competition law. But currently we are working with Professor Olabisi on a publication that is looking at the issue of open access and publication infrastructures, and how they enhance the development of scholarly work from developing countries. For instance, the issue of desk ejections, like when you send your paper and the reviews come back and you have to you're told, no, do this, you have to use this theory is not applying to the African context. You want to focus, you want to show how Pan-Africanism is influencing the development of international economic law, but you are told, no, you have to look at this, which is a theory that, for example, a theory like intergovernmentalism, which looks at the role of member states. In my research, as a competition law in Africa on the competition regime, I found that non-state actors play a key role when it comes to enforcement of policies, especially external. And sometimes when it comes to domestic actors, lawyers have a greater role in influencing development. So sometimes the institutions that understand the policy are able to drive the change. So in one of the papers that is not here that will be out soon, I was looking at the issue of how when the Competition Commission was pushing for the domestication of the competition regulation, why is it that some countries did not domesticate the COMESA Treaty while others did? So you look at a country like Malawi, it hosts the COMESA Competition Commission, but even when the National Competition Authority pushed for the domestication of the COMESA Treaty, it never happened because it's not their role. It's the role of actors like the Attorney General. Yeah, those are the ones that are the gatekeepers, that they decide whether that bill will move on or not. You look at countries like Zambia, which hosts the COMESA Secretariat, while Zambia has not ratified the COMESA Treaty. So what did COMESA do? It had to look for another alternative. So it realized that we work very close with the national competition authorities. And the national competition authorities have the agenda setting power to initiate legislative initiatives at the national level. So what do? Let's work with them so that they can push for amendment of the competition laws, include the provisions that grant them the obligations to support and cooperate with the regional competition authorities. So now the obligation now comes to the national competition authority officials. So by using the national competition authorities to repeal the national competition laws, now we don't have the problem of the applicability of the commercial competition regulation, even in the absence of the domestication of these laws. So those are some of the things, and I'm looking forward to your questions.
Thank you very much. That was a really interesting and very comprehensive overview of the